Good morning, everyone. Welcome to Convocation, and welcome to anyone who is joining us on the public webcast today. This will be our fourth webcast as part of a pilot project to provide online viewing of Convocation. This is part of our commitment to continued transparency and accessibility about our governance process and to offer an up-close look at the way Convocation works and its consideration of policy issues. We'll be reviewing the concept of webcasting Convocation for future meetings based on this experience next Convocation. And we will have, of course, some evaluation which will have us taking into account human and financial resources, numbers of viewers of the webcast, attractive whether there are methods we can explore to make convocations or deliberations available using some other methods. So I expect we'll have a report then for Convocation next month. I'd like to review the instructions for the phone system for those participating by phone. Once we determine who is on the phone, I'll let everyone know that we'll be placing those calling into the meeting in what we call lecture mode. This means that from our end, we are muting all callers. Once muted, they'll be able to hear the meeting but can't speak. So we will be, in other words, pressing *6 from our end. And I'm not sure who's officially in charge of that now. Mr. Lerner, thank you.
Temporarily.
Yes.
I'm on probation.
Okay.
You'll get a point.
Okay, of course we'll need to come out of lecture mode to hear callers who wish to speak and vote. And we'll do that following presentations of reports and motions. So at that time, unless callers wish to speak, please *6 your telephones as we have done in the past, and we'll be repeating this throughout Convocation as necessary. I'd like now to go to the list of persons on the phone. First, benchers. Thank you. Benchers who have indicated they'll be on the phone. Mr. Bird.
Present.
Mr. Finkelstein.
Yes, present.
Ms. McLean.
Present.
Thank you. Mr. Baines.
Present.
Ms. Richardson.
Present.
Mr. Ruby. Mr. Strasberg.
Good morning. Good morning, Kathy. I love you.
Mr. Ikedi. We also, and I will be mentioning this later, we have recently received the appointments of 2 new lay benchers, and I believe that Ms. Clement, you may be on the phone. Is that correct?
Yes, I am. Present. Thank you.
Thank you. We also have today, anyone else who are benchers on the phone? Okay. We also have on the telephone today 3 guests, and I'll be coming to the purpose for that later, but just to confirm they're on, Ms. Platt, Mr. Rosenberg,
Yes.
okay, and Ms. Rosenberg.
Present.
Thank you. We'll come back very shortly to our business with you. So, first on the list of business, as a result of my re-election on April 30th as bencher, and since I resumed the office of treasurer at that point,
Is in lecture mode.
we need to elect a bencher from inside Toronto and also elect a regional bencher to replace me. The motion is at tab 1 for the election of Janet Leeper as regional bencher for Toronto region and the election of Isfahan Morali as a bencher in the Toronto region. And the motion is moved by Jacqueline Horvath and seconded by Kathy Corsetti. Taking that would mean no discussion. Okay, all in favor?
Thank you.
Okay, and then is Ms. Morali?
Thank you very much.
I'd also like to advise Convocation as for your information, that Robert Lapper, our CEO, who normally attends every convocation, is away today attending to some urgent business on behalf of the Law Society and me, the treasurer. And I was wondering who would assume his chair, and I must tell him that it remains empty, so he will be in our thoughts. We'll see Mr. Lapper back at Convocation in June. Now, next, I'd like to welcome all of our newly elected benchers. Peter Beach from the East Region, Fred Bickford, Northwest Region, Paul Cooper, Central East Region, Diane Corbiere, Central East Region, Janice Krieger, Central South Region, Teresa Donnelly, Southwest Region, Raj Sharda, Central West Region, Andrew Spurgeon, Central South Region, Joanne St. Louis, East Region, Jerry Udell, Southwest Region, and Ann Despry, East Region. From inside Toronto, Rocco Galati, Joe Groya, Isfahan Morali, Sandra Nishikawa, Gina Papagorgio, Jonathan Rosenthal, and Sydney Troyster. As I noted earlier, we have 2 new appointed benchers. We received notice from the government just very recently, and it seemed not possible for them to attend today's convocation, so we will be meeting them next convocation, and I'll be saying something more about them. But I'd like to welcome Suzanne Clement of Ottawa, who's on the phone this morning, and Giselle Chrétien of Sudbury, who is not able to attend today. So congratulations to both of them on their appointments. Look forward to meeting them in person next convocation. And finally, congratulations to all of the benchers who were re-elected. I'm sure you're breathing a sigh of relief now that the election is over. There will be some interesting and challenging work ahead for us, and I look forward to working with everyone. As you know, we've already commenced the strategic planning process to identify priorities for the new bencher term. Benchers should not hesitate to reach out to senior management team for information and assistance. They are here to assist benchers in their duties as governors. I know that all of you are very enthusiastic to take on work as benchers, and many have ideas for change. I would ask, and I'm asking on behalf of the CEO, when benchers are looking for information, it's most helpful, of course, to go to staff. However, would you please direct your request to senior staff, and they can direct you to staff in their divisions who can provide it, or they'll provide it themselves. Going directly to staff can be confusing and not that helpful. Secondly, if you want to ask staff to actually do something, especially if it is going to involve external relations, I'd ask that that request come through either me or the CEO. Thank you. I'd like to acknowledge at this point all the work of our former bencher colleagues. We've had quite a good 4 years together, and they've all made very significant contributions as benchers. So that, I'm going to just list them out. First, Constance Backhouse, John Campion, Mary Louise Dixon, Larry Eustace, Peter Festeriga, Alan Gold, Jennifer Halajian, Susan Hare, Nicholas Pistina, Linda Rothstein, Mark Sandler, James Scarfone, Alan Silverstein, Joseph Sullivan, and Beth Symes. And I think we all worked together. In my view, we accomplished a lot, and no matter how much we disagreed on specific issues, I think we worked together in a very collegial and collaborative way, and I look forward to that continuing this year. Finally, I'd just like to make remarks about the eagle feathers in front of me. For newly elected benchers, I'll just take a moment to draw your attention to them and why they're here. The Law Society was gifted with these feathers at a special call to the bar ceremony in October 1998 by Peter Kelly, an Ojibwa elder. They were presented to then Treasurer Harvey Strasberg, along with the 2-row wampum belt that hangs outside of Convocation Room. The feathers were presented for a purpose, to symbolize the strength of the relationship between the Law Society and First Peoples. And as we've come to learn more through the work of former bencher Susan Hare since 2013, we also now understand that they are tools. They have been used by Diane Kelly and Elder Alex Jacobs to share teachings with the benchers, enabling us to understand concepts and relationships from another perspective. And I recall Susan Hare telling Convocation that their presence was designed to bring focus, clarity and honesty and humility to our discussions and ultimately promote harmony. So may that continue. In taking their place in this room, they've become an important reminder of our broader purposes, and they remind us of our relationship with the First Nation, Métis, and Inuit community and our commitment to furthering equity and diversity in the legal profession and our access to justice mandate. I'm pleased to announce at Convocation today the 6 distinguished individuals who will be receiving the degree of Doctor of Laws honoris causa from the Law Society at the upcoming Call to the Bar ceremonies this coming June. The 2015 recipients are Janet Stewart for the London Call on June 18th. Janet Stewart is a senior legal practitioner in London at the firm of Learners. Next, the Honourable Peter Milliken, former Speaker of the House of Commons, for the June 22nd Ottawa Call. Julian Porter, who needs no description, I think, June 23rd. Sheila Block, litigator from Tories, June 24th. Jean Taillé, prominent Métis lawyer, June 26th, called to the bar in the morning. And James Stewart, who's now at the International Criminal Court, on June 26th in the afternoon. I'm most honored to have that outstanding group of individuals that they will have had honors conferred upon them during my term as treasurer. Some benchers will recall in November Convocation that we approved the conferring on the Honorable Mark Rosenberg the degree of Doctor of Laws honoris causa. We were hopeful that he would be able to accept the honor at the January Call to the Bar. Unfortunately, due to health issues, that was not possible. At the request of his family, I conferred the degree over the phone last Friday, May 22nd. I invited Mark Sandler to read the citation, and I'd like to invite him to do so again today at Convocation. When we conferred the degree, his family and partner were in the room with him, along with his mother. And I invited the family to join us by phone today. Those are our guests on the phone, to hear Mark Sandler read the citation. Mark, are you here? Right, thank you.
Good morning, everyone.
So again, maybe I should just reiterate, we have Priscilla Platt, Daniel Rosenberg, and Deborah Rosenberg. Thank you again for joining us. Mr. Sanders.
Thank you, Treasurer. I should say that last Friday at our special convocation, I was honored to be reading Mark's citation to him in the presence of his family. I've known Mark as a colleague and judge, friend, mentor, educator, and truly inspiration for almost 35 years. And I've watched Deborah and Daniel, his children, who are on the phone today, become successful, lovely, and unique individuals that Mark is so proud of. It would be difficult to imagine anyone more respected, admired, and indeed loved professionally or personally than Mark, and therefore it would be impossible to imagine anyone more deserving of this honor. The citation, which was lovingly composed by Madam Justice Catherine Corrick, one of Mark's dear friends, reads as follows. Treasurer, may I present to you and this convocation the Honorable Mark Rosenberg, and request that you confer upon him the degree of Doctor of Laws honoris causa. Soon after his call to the bar in 1976, Mark Rosenberg rose to prominence as one of Canada's finest criminal appellate lawyers, appearing as counsel before the Supreme Court of Canada and the Court of Appeal for Ontario hundreds of times during his 19-year career as a lawyer. He served as a director of the Criminal Lawyers Association, as a consultant to countless committees and commissions, and as Assistant Deputy Attorney General. He has been committed to giving back to the legal community, generously sharing his expertise with the next generation of lawyers, as a teacher at Osgoode Hall Law School, and as head of the Criminal Procedure Section of the Law Society's Bar Admission course. He was an associate editor of Canadian Criminal Cases and is the co-editor of Martin's Annual Criminal Code. He has written extensively on criminal law, evidence, and the Canadian Charter of Rights and Freedoms. Following his appointment to the Court of Appeal in 1995, Justice Rosenberg continued his commitment to education. He has been truly an innovator in judicial education, bringing problem-based learning to hundreds of judges in Canada and throughout the world in places like Vietnam, the Ukraine, China, Jamaica, and throughout South America. Justice Rosenberg is regarded by all who know him as a man of great integrity, intelligence, judgment, and unfailing humility and elegance. He has made an indelible mark on the criminal law of this country as a lawyer, teacher, and jurist. The Honorable Mark Rosenberg is deserving of the highest honor this society can bestow, and I ask you, Treasurer, as I did last Friday, to confer upon him the degree of Doctor of Laws honoris causa. Thank you.
Thank you. Thank you, Mr. Sandler. And to the family, again, we offer our congratulations. Please convey that to Justice Rosenberg, and as I indicated last Friday, we will be arranging a time to present you, the family, with the hood and bound citation. So again, thank you very much for joining us. All the best, and you don't need to stay to hear the rest of the business. I'm sure you have other things to do, so thank you very much.
The conference is no longer in lecture mode. The conference is in lecture mode.
Thank you, Mr. Sandler, for joining us this morning. I would like to take this opportunity also to advise Convocation that Mr. Sandler has just been named the recipient of the G. Arthur Martin Criminal Justice Medal. Is for outstanding contribution to criminal justice offered by the Criminal Lawyers Association, and I understand this will be awarded at their fall conference in October. Very deserving recipient. And now, Mr. Sandler, I believe that completes your duties as a bencher.
Sayonara.
I think you've expired. Thank you so much for
Enjoy
coming.
your delivery.
Well, and I know that Convocation will be welcoming you back on other occasions as you'll continue to serve the society from a slightly different perspective. So thank you very much.
Thank you, Treasurer.
Next, the bencher election. Now that it's over, as we have done in the past, we'll have an opportunity to look at our process and see if there are ways we can improve it for the next time round. As you know, unfortunately, voter turnout decreased from 37.12% in 2011 to 33.84%, slightly lower than the election in 2007. This year, the elections officer, who's Jim Vero to my right, has noted a number of issues arising from the election process. And I know we've also had some informal discussions amongst ourselves about that. I'll be asking the Governance Issues Working Group of the Priority Planning Committee to review these issues and to bring forward any proposals the working group deems appropriate for Convocation's consideration through that committee. So we'll be coming back to that, and of course that committee will be consulting benchers during their deliberations. I now also have some sad news to turn to. We were all saddened to learn that former Law Society Treasurer, the Honorable Dan Chilcott, passed away in Ottawa on April 28th at the age of 86. He was highly regarded by members of the bar, the judiciary, and he was voted Treasurer of the Law Society for 1987 and 1987-88 term, having served as an elected bencher from 1979. In 2007, the Law Society bestowed upon Mr. Chilcott its highest award during the Ottawa Call to the Bar ceremony, the degree of Doctor of Laws. The memorial is being held today in Ottawa, and I've reached out to his family and passed on condolences on behalf of Convocation. He was a dedicated mentor and, of course, importantly, had many professional achievements, both as a lawyer and a judge. He was a model of integrity and I think reflected so many of our values. He talked about hard work, humility, honesty, and humor, but the most important being integrity and common sense. So again, I extend on behalf of Convocation our condolences to the family. Dan Chilcott will be missed. Alan Bourvoy, the civil liberties champion who served as general counsel for the Canadian Civil Liberties Association for more than 40 years, passed away on May the 11th. Mr. Bourvoy, born in Hamilton, had his education at the University of Toronto and received his law degree in 1956. He was made an Officer of the Order of Canada in 1982. We awarded him an Honorary Doctor of Law degrees in 1995. He had also received the Law Society Medal. For over 40 years, Alan Bourvoy fought for fundamental freedoms and human rights and contributed to great advancements in civil liberties in Canada. Again, he will be much missed. The Law Society Awards ceremony was held last night, and I'd like to congratulate all of the award winners. This year's Law Society medalists are Craig Carter, Professor Adam Dodek, Susan Eng, Faisal Joseph, John B. Laskin, Stuart Lavigueur, Patrick Shea, and Chantal Tai. As well, for our designated medals, Paul Dre received the William J. Simpson Distinguished Paralegal Award, Paul LeVay, the Lincoln Alexander Award, and Kim Murray, the Laura Legg Award. Again, I speak for all members of Convocation, I'm sure, when I say that we are honored to call these recipients our professional colleagues. We thank them not only for their significant contribution to the lives of Ontarians, but also as role models for the rest of us in the profession and hopefully in the minds of the public. I'd also like to thank our former bencher colleague, Bill Simpson, who assisted with the presentation of the William J. Simpson Award. Congratulations to all of the award winners. I was honored to be invited to give greetings on behalf of the Law Society at the swearing-in of the new Chief Justice of the Ontario Court of Justice, the Honorable Lise Maisonneuve. Very much look forward to working with the new Chief Justice through the balance of my term and in the future. The CADILPA plenary was held in Thunder Bay. Unfortunately, it conflicted with the time of the swearing-in ceremony, so I wasn't able to attend. Robert Lapper and other staff members attended and provided a general update on current issues and activities here. And I understand from Mr. Lapper that the plenary was very successful and went very well. On May the 6th, the Law Society held a program for Mental Health Week called Fostering Wellness, a discussion of mental health and the legal profession. We had 200 people attending in person and approximately 1,000 viewing the webcast. This speaks volumes. What was quite evident from the questions that were posed was, among other things, the very strong concern that seeking assistance could somehow result in stigma. And this, I think, is a very unfortunate feeling for those people who need help. It takes great courage to speak out about problems, and as you know, the Ontario Bar Association President Orlando da Silva has repeatedly shown that courage in talking openly about his own struggles with depression and also unjust stigma. He spoke at Convocation and shared some of his experience with us. On May 22nd, he also shared his experiences at the OBA program, All Rise, a summit of mental health in the professions. And that brought together not just the legal profession, but for other professional associations, to discuss mental health issues and talk about strategies for dealing with that. I attended, and it was an excellent program. Clearly, this is a serious issue that we must deal with as a profession. We continue to work to ensure that our members are provided with assistance and support to deal with their own issues through the Members Assistance Program, or MAP. To remind all of us, this program provides lawyers and paralegals and their families a full range of professional confidential services, including counseling, peer-to-peer support, crisis management services and substance abuse counseling, lifestyle and specialty counseling, as well as online resources and peer resource tools. We also have our Discrimination and Harassment Counsel program, which is provided free of charge, and that provides assistance to licensees who experience discrimination and or harassment from other lawyers and paralegals because of mental health or any other issues. These tools and supports are there, and I'd encourage you to promote them as benchers. It's a bigger issue for all of us to consider in the future, and I expect next June I'll be announcing that we are going to have a task force looking at mental health strategies for adoption by the Law Society. And as I say, more details on that in June. And I now notice Mr. Gottlieb has assumed Mr. Lapper's chair, so I will pass that on. Okay, targeted legal services. On May 12th, I attended the second of a three-part series on the interplay between targeted legal services and access to justice. It's presented by the Law Society through our action group on access, TAG, and it was presented to Justice and Social Justice Tribunals in Ontario. Again, they were full the sessions were full to capacity with additional attendance by webcast. It's clear that the profession is interested in learning more about targeted legal services and in particular limited scope retainers. Bencher Shapus, I believe, also participated in that panel. I look forward to the third session in the series, which is scheduled for September 16th, and I'd encourage benchers to attend and participate in the discussion. Yesterday, Bencher Faulkner and I had an excellent meeting with Chief Ava Hill and the Justice Committee at the Six Nations of the Grand River as part of our Aboriginal outreach strategy. Grant Wedge and Marisha Roman from our staff ably assisted and attended with us. I look forward to continuing to visit First Nations to communicate directly with them about the role of the Law Society, obligations of lawyers and paralegals to their clients, and to understand what challenges First Nations see in access to justice. As I mentioned, the calls to the bar are coming up in June, and as well we have a number of other events which you have heard about. I'd like to point out that we have public events sponsored by the Equity Division along with partners from the legal community, and I'd like to urge benchers to attend those when possible. The next one is on June the 2nd, Access Awareness event. The panel will discuss the Carter decision on physician-assisted suicide. Where do people with disabilities go from here? The panel is scheduled from 4 to 6, and there's a reception following. And if you're unable to come to the panel, everyone is still welcome to come to the reception, and I would urge you to do that. Our Pride event will be June 23rd. The panel, again, will focus on challenges faced by the LGBTQ youth community and will take place at 5 in the Lamont Learning Center. Again, there will be a reception to follow. That will be at 6:30 in Convocation Hall. We have a number of luncheon guests attending Convocation today. The Honorable Convocation lunch today. The Honorable Heather Forster Smith, Chief Justice of the Superior Court of Justice. The Honorable Frank Morocco, Associate Chief Justice of the Superior Court. The Honorable Faye Finstead, Associate Chief Justice of the Ontario Court of Justice. Chief Justice Maisonneuve, newly minted, was scheduled to attend, but unfortunately her schedule was such that she was unable to do so. She sends her regrets and looks forward to attending a later event. And again, we offer congratulations to Justice Maisonneuve. Before we turn to the agenda, primarily for the information of new benchers, I'd like to remind you that on occasion, we will proceed in camera with convocation business. This is based on the guidance provided in Convocation's Rules of Procedure and Bylaw 3 on this subject. Which indicates that convocation shall be held in the absence of the public to deal with any of the following matters. Matters relating to society's personnel, litigation in which the society is involved, negotiations with the government, intimate financial or personal matters or other matters in respect of which, in the opinion of the benchers present, the need for privacy outweighs the public interest in disclosure, and any matter at the instance of the treasurer. The majority of our agenda is in public, and I strive to have as much in public as possible. Occasionally, nonetheless, the need will arise for an in-camera session, and we will today be having a short in-camera session at the end of the public business. I remind benchers that discussions in camera are confidential. They must remain confidential, as does the material which you receive associated with those confidential discussions. On occasion, we will have discussions in camera and then go into public to announce the result of them. Those are reported in public at a later time. But some matters always remain in camera, and I ask you to honor that obligation and commitment. I'll be happy to speak with anyone about this after convocation if you have any questions. So let's turn to the agenda. First item on the agenda is the consent agenda. And that is moved by Jacqueline Horvath, seconded by Kathy Corsetti. Does anyone have any issue with anything in the consent agenda which would require us moving it out of the agenda for discussion? Oh, sorry, Ms. Ross.
Thank you, Treasurer. I don't know if this is true of everyone's board books material, but at tab 2.2 motion-appointments, mine simply reads materials to follow when available. I don't have any materials.
You have to update.
I believe it was loaded this morning, Ms. Ross, but it should be on as an update if you check your list.
It's there, you have to update your board books.
Thank you. Thank you very much.
Thank you. There are no questions on that agenda. I'm going then to call the vote. All in favor? And I should have asked if there were any questions on the phone. I apologize.
The conference is no longer in lecture mode.
Were there any comments or questions on the phone? Okay, if not, I have called the vote. Any opposed on the phone? Okay, thank you. Motion passed.
The conference is in lecture mode.
Next is our motion for the appointments to the Law Society Tribunal. Mr. Anand, are you speaking to that?
Yes, thank you, Treasurer. I'll be very brief, and this is mainly just to familiarize new benchers who will be new adjudicators with the process. This is simply a renewal or reappointment of incumbent benchers for 2 years, those who indicated their wish to continue to serve on the Law Society Tribunal, as well as the 2-year appointment of new benchers who wish to serve on the Law Society Tribunal, and who in their case will begin sitting after the completion of the 4-day intensive training course, which has begun. And in addition, there are appointments of myself and Chris Brett as vice chairs of the 2 hearing divisions to attempt to replace Mark Sandler and Linda Rothstein. And you'll hear more about Ms. Rothstein later. Good luck with that. So that, the motion is moved by Jacqueline Horvath and seconded by Kathy Corsetti.
Right? Any questions or comments in the room? Mr. Gottlieb?
Treasurer, through you and Mr. Anand, I apologize for not raising this before with you, but I just want to point out to you something for your consideration in the future. If one is a sole practitioner bencher or ex officio bencher, the present requirements to be able to serve on the tribunal are that you commit to a minimum of 10 days. For some of us, that's difficult. And notwithstanding assurances that one would not be called to sit upon for 10 days, still, you are required to sign a form stating that you will commit to 10 days. I think that creates an impediment for some benchers and ex officio benchers to serve on the tribunal, and I would ask for you to sometime in the future consider that requirement and amending it.
All right, thank you, Mr. Gottlieb. You've raised this issue before, and as you know, under the Tribunal Reform Report of, it's now 3 years ago this June, which was passed, there are requirements which the chair is entitled to impose as a condition in order to bring together the adjudicators who are necessary. And certainly I've heard what you've said about that, and certainly the chair, who's here, Mr. Wright, has heard that as well, and that'll be considered.
Thank you. Any other comments or questions in the room?
The conference is no longer in lecture mode.
Comments or questions? Comments or questions on the phone? In case, call the
conference
vote.
is in lecture mode.
Moved by Ms. Horvath, seconded by Ms. Corsetti. All in favor? Any opposed on the phone?
The conference is no longer in lecture mode.
I'm confused.
Is that a question or a vote? Okay, thank you. The motion carried.
The conference is in lecture mode.
Next item on the agenda is a report from the Professional Development and Competence Committee, Mr. Goldblatt.
Thank you, Treasurer. If I may, just take a moment to welcome as well the new benchers to Convocation. And if I might just say, as an aside, that I trust that my reports will be greeted with the same spirit of enthusiasm and approval that has characterized Convocation in the past. Can't remember the last time that happened, but let's start a new tradition today, if we may. My report, Treasurer, is found, actually the motion is at page 41 of board books, please. And it is a motion moved by myself and seconded by Ms. Haig. Convocation approve the amendment of relevant Law Society bylaws to ensure that they enable law student experiential learning, provided that law students are adequately supervised, and second, that the bylaw amendments be provided for Convocation's consideration in June 2015. And let me just emphasize that we are not today debating the content of these proposed bylaws. The joint meeting was held with professional development and competence, access to justice, and paralegal standing to debate the motion that is before you today, and that is to enable us to go forward and to develop the bylaw and to consider and debate the bylaw within the joint committee structure as a matter of efficiency, and then bring it back to Convocation where obviously it can be subject to further discussion, debate, amendment, and so on. So the purpose of today's motion is merely to set further in process the review of our bylaws and the amendment to the extent that Convocation approves it. Let me also just say very generally that the purpose of the motion and the purpose of the review and proposed amendment to the bylaw is to continue what has been an ongoing process by the Law Society, and that is to ensure that the programs that are made available and the practice within the profession is reflected appropriately and consistently within the bylaws. And this particular issue addresses what is referred to as experiential learning for law students, which, as the material indicates, is a developing area amongst what are referred to as SLASs and otherwise, student legal aid service providers. And there's a very useful background paper that benchers can find at 4.1.1, page 46 of board books. Now, the particular issue arises because there is a concern that the bylaws may not conform to what is being proposed with respect to experiential learning. And as the material before Convocation indicates, it has always been and it continues to be a priority of the Law Society to promote legal education and pre and indeed post-call competence. Also, it's also a priority to assist to the extent possible the public and to provide improved access to justice. All of this conforms with the experiential learning which are provided to law students and which are developed and presented in the ways that have been set out within the material. And so for all these purposes, both with respect to reviewing our bylaws, with respect to ensuring that the bylaws are appropriately reflective of what the practice is, to promote experiential learning, which has generally been viewed as valuable both with respect to the students as they prepare and as they ultimately enter the profession, and with respect to the public that we serve, we're asking that Convocation give approval to further development and returning to you with the proposed bylaw. And as I said, Treasurer, that is moved by myself and seconded by Ms. Hayes.
And so my understanding is today you're asking for approval in principle, and next Convocation, assuming there is some approval given, the bylaw will come back for further approval.
Correct.
Thank you. Any questions or comments in the room?
The conference is no longer in lecture mode.
Shoot, is that new?
No.
Questions or comments on the phone, and someone is online who doesn't want to be?
Every single time.
Well, I'm consistent.
Could I have some attention, please? Okay, you need to mute your phone.
You prefer what?
Someone needs to mute his or her phone, and it sounds like a his.
Mr. Yaketi, mute your phone.
Thank you. Let's start again.
Order of ranking, it goes
Mr. Yaketi,
Can't.
Mr. Yaketi, you're online for all of Convocation. Somebody's going to email. Can we go back to the room?
Lecture mode.
Go back to, there were no questions or comments in the room, and I'm going to assume there were none on the phone. Okay, unless there's something further, I'm going to call the vote. Oh, I'm sorry, Mr. Wright.
Thank you, Treasurer. Just as a matter of process, I wonder if it's wise to be approving things in principle without knowing the details. Why not just defer it till next month, bring it back as a proposal with details that have been fleshed out? It seems odd to approve something when we really don't know what it's going to look like.
Treasurer, it's my understanding, pardon me, this is the process by which we need to review and prepare the bylaws for the Convocation's approval, and that's the process that we're following, just to give you a heads up as to what it's about, and actually you'll be able to follow it on board books. Will be posted as soon as possible. And it also helps to focus when we come back to Convocation in June, if everything is ready in June and gone through the appropriate committees, to have a much more, as I say, a focused discussion of the bylaw, and all of the issues will be quite apparent at that point.
Well, just to follow up, I'd say it should be presented as an information item today, but I'll say no more.
I think we're going to have a vote on principle. So, all in favor? Any opposed? Opposed on the phone?
The conference is no longer in lecture mode.
Opposed on the phone? Thank you. Motion carried.
Thank you.
The conference is in lecture mode.
Next is the Equity and Aboriginal Issues Committee report on Human Rights Monitoring Group interventions. Mr. Shavis.
We're retired now.
Thank you, Treasurer. For the benefit of all of the new benchers, this is a regular event at our convocations. The Human Rights Monitoring Group, which has a mandate of receiving and reviewing information about lawyers and judges around the world who are being affected or persecuted because of their activities in advocating for the rule of law. When those come to our attention, we review that information and we bring proposals to Convocation that the Treasurer write letters and the Law Society issue public statements calling for inquiry or otherwise raising concerns about the violations of the rule of law. As we put it in our letters, and we send these letters often to heads of state and heads of law societies and senior government officials, when serious issues of apparent injustice to lawyers and the judiciary come to our attention, we speak out. And that we see as part of our mandate to uphold the rule of law. So this month there are 3 matters before Convocation. The first, and they are contained at 5.1, beginning at page 63 of board books. The first one deals with a prominent human rights lawyer in Azerbaijan who's the head of the Legal Education Society there, who was accused last August of various offenses that appear to be politically motivated and part of government pressure on human rights defenders. The lawyer's name is Intigam Aliyev in Azerbaijan, and the proposed letter and statement are at 5.1.1 or page 72 of board books. The second one deals with Aza Soliman. She is a human rights lawyer in Egypt, the founder of the Center for Egyptian Women's Legal Assistance, and she is facing charges for being involved in protests after she observed police brutality and went to the prosecutor's office to complain about it. And this appears to be an ongoing part of the systemic attack on human rights defenders that we're all aware of has been going on in Egypt. Again, the proposed letter and statement are at 5.1.2 of board books. The third proposed intervention deals with Pakistan and the murder of a lawyer, Samiullah Afridi, who was shot by unidentified assailants. Later, a Taliban group claimed responsibility after he had gone on the record to defend, although he subsequently withdrew because of threats, to defend a doctor who had allegedly assisted the CIA in their hunt for Osama bin Laden. And we have drafted a letter and a proposed statement urging the government of Pakistan to take steps to secure and protect lawyers and other advocates for human rights and to ensure that a fair and impartial investigation of his murder is conducted. And that proposed statement and letter are at 5.1.3. So those are the proposed interventions moved by me, Treasurer, and I'm pleased to say seconded by one of our new benchers, Ms. Donnelly, who attended our Human Rights Monitoring Group, and I'd urge others to attend in the future if they're so interested. Thank you.
Thank you. Any questions or comments for Mr. Shavis?
I have, Madam Treasurer.
Okay.
I
Mr. Galati. Just a moment, Mr. Galati. Do you want to just step up so you're near the microphone?
Sure. I fully support the initiative, Mr. Shavis, of this committee to recognize an assault on the rule of law around the world, but I would strongly urge that the Law Society doesn't have a 500-mile liberal syndrome. Lawyers in Canada have come under death threat, myself included, serious death threat, I was referred to the Minister of Immigration last year as a depraved counsel to the Cantor family in the House of Commons and on CBC, suggesting I share Al-Qaeda philosophy. The Law Society should have intervened, and there's 7 now lawyers in the States, two of whom have been assassinated under suspicious circumstances, one who's died of cancer in New York, for their work. So we should also look to home when it's happening at home, both here and south of the border. Thank you.
Mr. Galati? Mr. Lerner?
Yes, thanks, Treasurer. Mr. Sheebus, we heard again yesterday.
Just a moment. We'll just wait till he's... Thank you, sorry.
Yes, we heard again yesterday a plea for the circumstances of the murdered and missing Indigenous women in Canada. I don't know whether this falls within the purview of this committee, but it occurs to me, following along in what Mr. Galati has said, rather than focus our ken to these other countries some distance from us, that seems to be an issue that is receiving a great deal of public response, and I suggest that we should lend our voice to the call for a public inquiry.
Mr. Lerner, Mr. Faulkner, I think I saw your hand.
Yes, as a member of the Human Rights Monitoring Group and someone who spends a significant part of my practice on Aboriginal issues, I obviously echo Mr. Lerner's sentiments, but I would point out 2 things: that we have to be somewhat realistic about how we tackle these issues. So the Human Rights Monitoring Group mandate is focused on threats by way of human rights violations to jurists and lawyers. Obviously, the very sad and tragic situation around murdered and missing Indigenous women and girls is not about necessarily jurists and lawyers. But it does raise this because as co-chair of Equity and Aboriginal Issues Committee Treasurer, I routinely hear concerns over our not acting in these key areas, whether it's Mr. Galati's very meritorious concerns or those just raised by Mr. Lerner and raised by Ms. Murray yesterday. And we may wish to consider one of 2 things: either simply bringing these issues to Equity and Aboriginal Issues Committee and having us look at them as a committee as to whether our structures that are currently in place can accommodate these concerns, or secondly, simply asking the question whether the mandate of the Human Rights Monitoring Group needs to be expanded. But either way, we're going to have to do something structurally before we can just jump out of the gate. So while I believe this is highly meritorious, the words think and then feel that we heard last night from a speech by now Assistant Deputy Attorney General Murray probably count. We have to think. So we have to think our way through this on how to do it right. But I do echo the sentiments by my last 2 colleagues.
Thank you. Any other questions or comments in the room? Questions or comments on the
The
phone?
conference is no longer in lecture mode.
Questions or comments on the phone?
Thank you.
Thank you. Oh, I'm sorry, Mr. Braithwaite.
The conference is in lecture mode.
Just on the matter which Mr. Galati has brought up and what Mr. Faulkner has said with respect to the structure that we should first take a look at, and I think we already do have the structure with respect to Mr. Galati's concern and working within the jurisdiction of Canadians.
Yes, I mean, thank you, Mr. Braithwaite and Mr. Galati. We do not have a radius in which we do not look. In fact, the monitoring group is currently corresponding with respect to concerns about a lawyer in the city right now. Thank you.
There's no further questions or comments. I'm going to call the vote. All in favor?
The conference is no longer in lecture mode.
Any opposed on the phone? Okay, motion carried.
The conference is in lecture mode.
We have under the Equity and Aboriginal Issues Committee some reports for information. And again, for the benefit of new benchers, we sometimes have reports spoken to when there's information and sometimes we don't. Today, I'm going to ask 2 of them to be spoken to. I think Mr. Faulkner, are you first?
Yes.
Thank you.
Yes, thank you, Madam Treasurer. Treasurer, I'll be addressing for the benefit of Convocation members, I'll be looking at tab 5.2.1, which is page 100 of board books. Tab 5.2.1. Essentially what myself, as co-chair of Equity and Aboriginal Issues Committee, along with my co-chair, Ms. Leeper, will be presenting on the staff report that's presented by the Equity Initiatives Department. The report itself starts at page 92 of board books, and it's the report of our director, José Bouchard, and her team. A lot of this work is extremely heavy lifting. The Equity Initiatives Department puts in long hours. And those of you who have an interest in this issue, I strongly urge you to talk to folks. We've gotten a caution this morning about issuing directives to staff. I probably am one of the worst at doing it, so I share everybody's desire to get things going. But at the same time, it is important that you talk to staff about what they do and how they do it, so you can get familiar with the kind of heavy lifting they're doing. Today, my task is to simply present to you some of the key components of the Equity and Aboriginal Issues Committee, how it was created, how it came to be. And so I start at page 100 of board books, 5.2.1, and try to give you a bit of the history of the committee. There was a key report, and you'll see this in paragraph 2 of the Equity Initiatives report. There was a key report called the Bicentennial Report that led to very serious systemic change to promote equality, diversity, and inclusion within the legal profession. The report actually spurred the creation of a standing committee, the Equity and Aboriginal Issues Committee of the Law Society in the mid-90s. The mandate that's set out at paragraph 2, and I'm going to take some time to detail it because that allows you to get a feel for our work. To develop for Convocation's approval policy options for the promotion of equity and diversity having to do in any way with the practice of law or provision of legal services in Ontario, and for addressing matters related to Aboriginal peoples and Francophones, and to consult with Aboriginal, Francophone, and other equality-seeking communities in the development of policy options. What you see at the next page, paragraph 8 of the report, is an Equity Initiatives Department was created. And paragraph 8 indicates what its broad mandate is to do, and that's to promote equality, diversity within the legal profession, to ensure inclusion and equality within the Law Society, and to build and maintain relationships with diverse communities and stakeholders. So right away, what you get a feel for is what drives our work from both an operational and a policy side. And you probably also get a feel for why, frankly, I think I have the best job. In my view, the work of this committee has historically and has the possibility of making huge changes in parts of the Law Society that our colleagues don't know so well. So we're all known very well for the discipline component of the Law Society. You heard the award recipients mentioned last night. Oh cripes, I got a call from the treasurer. I still get nervous when I see a Law Society emblem on an envelope, and I've been a bencher for 5 years. We all out there, the 47,000 lawyers, we understand the discipline component.
Are there reasons for that, Mr.
I thought we'd clean that up. But do they know us in any other way? Do they know us as support? Now we know a perfect example on the mental health issue. We know about MAP. We know about our initiatives. But what it feels like is there's a great disconnect. That great disconnect's reflected in the voting. 34%. Shameful. The great disconnect is reflected in the fact that many, I say it candidly, it's only my opinion, but it is my opinion, that for many the Law Society has little relevance in their day-to-day life other than if they're in trouble. We need to bring home the inclusive nature of our work. The fact that we're here not as a regulator to discipline, but to support. And that's where our committee becomes, in my view, of great importance. Now, I'm supposed to read you a whole bunch of chunks of this report. I don't have to. You can read, or you can not read because you don't care. But what I want to emphasize is what you'll see in the next 10 to 15 pages that I'm responsible for, talking to you about, is the role that we play, for example, with the Aboriginal bar. You'll learn that our Aboriginal Initiatives and Policy Council, Marisha Roman, spends great scads of time reaching out to members of the Aboriginal Bar and creating supports and networking opportunities. But more than that, we have elevated Aboriginal issues front and center. Once Janet Lieber and I started co-chairing with the support of Vice Chair Hare and Vice Chair Symes, we determined that Aboriginal issues should be first on the agenda at every meeting. Why? Because we felt like it had gotten lost. The appointment of Grant Wedge as Equity Director has made a huge difference to what we now call our Aboriginal strategy. What I'm trying to say is a perfect example of what we thought had to be strengthened, and we're doing it. But we need to do lots of work. There's a lot of platitudes. I'm not convinced that we've delivered as many concrete steps as we can. In other areas that we're proud to talk about, the Human Rights Monitoring Group, you've just heard from Mr. Shabas about its mandate. We awarded Irwin Kotler the first Human Rights Award in February, and I was extremely proud to hear the words of the Treasurer, to hear the words of Mr. Shabas as the Chair, and to see the huge community support for Mr. Kotler's work and for the work of the Human Rights Monitoring Group. All of this is to say there's a whole part of the work of us as benchers that you need to dig into and get excited about, because from a policy perspective, you can actually make a difference, a huge difference on equity and access to justice issues. Thank you, colleagues.
Ms. Faulkner. Ms. Lieber.
Thank you, Mr. Faulkner. Treasurer, through you to members of Convocation. The work that we do at Equity and Aboriginal, and the work that's reflected in the report that's before you, is really rooted in relationships and collaboration, and it's more of an outward-facing set of policies versus some of the other committees at Convocation that are more about the inner operations. So that's one way to frame it and think about it. One of the other ways that I think about it is I often bring back our work to our mandate under the Act. And as you know, Section 4.2 prescribes a number of duties for the Law Society, including the duty to facilitate access to justice for people of Ontario. So how do we do that? It's a very broad idea, and we often have debates about what it means, but we are served by having a diverse yet connected profession. We have a diverse population. We serve a lot of people across a large geography. And although we don't ourselves deliver legal services, and that's reflected in the use of the verb facilitate, rather than deliver. We serve as a connector, a referral service, we build legal communities, and we facilitate. So in framing this part of the report, I begin by noting that equity initiatives are integral to the building of legal communities and to foster our collective abilities to serve Ontario. And that's why it's an exciting part of our work. It's a proactive part of our work, and we hope contributes to some of the other things, including proactive measures that perhaps avoid people falling into isolation and perhaps at risk of bumping up against the harder edges of our regulatory mandate. So, going back to collaboration, you will see first under working advisory and monitoring groups in the report at page 110, we begin by talking about our equity advisory group. So you'll hear lots of acronyms. I'm going to try not to use them during this report, but you will eventually start using them yourselves, and that's when you'll know you're truly comfortable here. But the Equity Advisory Group is a group of non-venture representatives from lawyers, paralegals, and other legal organizations who have expertise in equity and diversity, and they serve to inform the work of the Equity and Aboriginal Issues Committee. All of their work is described in the last little while. I'm not going to read it, I'll just refer to it. It's at paragraph 54 of your report. You will also see in the report that's attached to this one, we have reappointed 3 new members who have served well the Equity Advisory Group. That is Jonathan Segill, Paul Scotland, and Sharon Basran, and their bios are in there for your reading. Another working group that I believe almost everybody who ran for Venture was aware of, because a lot of people talked about this work, but I'll mention briefly the challenges faced by Racialized Licensees Working Group. This working group has been working through 2 reports since 2012 and is working on its 3rd report to come back in the fall on policy options to address the challenges that were first set out in the first report. And again, it's described starting at paragraph 55. And it's an exciting time because it's the kind of
policy work that involves a lot of consensus across the profession. In spite of some fears at the beginning that there might be some pushback on some of the findings, in fact, we find the profession is quite ready to have a discussion about what the role of the regulator is and how the regulator can accelerate and be a catalyst for change in a positive way to meet those challenges. And if you have any doubt about how the profession is composed, I love the list of bullets that Madame Bouchard has enclosed at paragraph 63. The list of interested groups on this topic is truly massive, and it has allowed us to generate a significant amount of enthusiasm and goodwill as we reached out, but it also gives you an idea of the face of the legal profession, if you didn't already have an idea, which I don't think many people here are lacking. The consultations that we've done continue on through the report. We also are gratified to note that there has been significant interest not only from the groups representing equity-seeking groups, but also from the larger firms. We've met with large firms across the law firm diversity and inclusion network, and there's great interest as well from that side of things in working with the Law Society. I'm going to move to page 114 of Board Books, where we discuss the retention of women in private practice working group. This goes back to 2008, but it's important because some of the policy projects that they created still continue to inform the work of Convocation and are still very much of interest to us. Essentially, this working group created a multi-phase set of policies. This was to enhance the retention of women in private practice because women were, and still are to some extent, leaving the practice in larger numbers than men. So the group set about to do some research to find out why that was and what could be done to perhaps change that. Again, to try to serve access to justice, to make sure we have a diverse set of lawyers, and to make sure that people with talents to give to the people of Ontario still give them. The first project you'll see described there is the Justitia project. This was a very innovative project because it was the first of its kind to really have a law society collaborate with firms to put together policies and practical tools and build them together to address this issue. You'll see the description of the collaboration in the report. It eventually went national. Other law societies adopted it, from the Barreau du Quebec, the Law Society of Alberta, British Columbia, Manitoba, and Saskatchewan. That's all described in the report. The work has continued to flow out from there. That's the kind of nice thing about this policy work. It then creates more ideas that build on the prior ideas. For example, last May, the Law Society had a Justitia Symposium with approximately 200 participants in person and 300 online. The Law Society continues to hold continuing professional development programs, taking the ideas and the learnings discovered as part of Justitia. The second area that was developed was a career coaching program for women who stepped away from practice and were coming back. You will see the criteria described there. I won't go into the granular detail, but this was launched in April of 2012, and there are coaches in both English and French available, and more than 25 women have access to it. You will also see reference to the Parental Leave Assistance Program. This program was created to allow more lawyers to be able to fund a smaller practice when they stepped away to either adopt or have children. It is a small amount of financial benefit for a defined period of time, and since 2014, a means test has been applied in addition to a number of professional requirements. These are all detailed at paragraph 85. And you will see that between 2009 and 2014, the Law Society assisted 60 parents annually. Since the means test was put in place, we have assisted 45 applicants. We are currently reviewing this program, and we'll hear more about it later, find out about how it has been effective, and that will come later in this term of convocation. The Law Society created a contract registry to allow lawyers in small practices to find people to fill for them when they either had to take leave for a variety of reasons or perhaps were on a big file. You'll see that described throughout the report after the Parental Leave Assistance Program description. Created a Women's Online Resource Center, and that was launched in December of 2010. That's at page 118 of Board Books for your reference. I'm going to move now to the Equity Legal Education Series, and the Treasurer touched on this in her opening remarks about the ongoing educational offerings that are provided. the basis for this is well set out, starting at paragraph 108, where we talk about not only the educational component, but the need for networking opportunities. And again, this relates to building communities of lawyers. These are well described at pages 121 to 123 of the report. I will note that we hold about 12 equity, legal education, and rule of law events per year. And it's a great chart. You'll see the chart starting at page 124 because it shows over time the number of people that attend has been increasing and the interest has been increasing. A large number of, again, external organizations partner with the Law Society, provide many opportunities to bring people together to discuss issues of interest. We have provided as well some of the comments from the people who provided feedback. I wanted to note that our director has written at paragraph 119 about, in fact, two of our events, the 2015 Holocaust Memorial Day and the 2015 Mental Health Awareness Program, both met their in-person capacity within 1 day of advertising. And so webcasting has been used to extend the reach of these programs so that more people can participate, and they have been enthusiastically attended. I'm not going to read the comments that are in the report. I want to talk briefly about our French language services because this has, as of 2014, the Equity Initiatives Department has also become the French language services unit of the Law Society, which is an important part of our mandate. And in the past couple of years, we've improved our capacity to meet our commitments to provide services to the public in French and in English. Par exemple, en 2014, le Barreau du Haut-Canada a adopté une politique sur les services en français pour ajouter à ses obligations découlant aux règles de pratique et de procédure. In 2014, the Law Society adopted a French language services policy. It's available online and it's hyperlinked in your report. We have signed protocols with the Office of the French Language Services Commissioner to address complaints that were received about our French language services. And you will see a complete description in that part of the report that talks about the variety of ways that we provide services, information, resources, and our website information in French. And we do have the capacity. 14% of lawyers in Ontario are capable of delivering French language services, and 3% of paralegals. We serve a population that identifies Francophone by 4.8%. You will see our key stakeholders. They're listed within the report. We consult periodically with the profession, and as you will probably know, there is a representative from AGEFO on the Equity Advisory Group. Our report also touches on services for persons with disabilities. The Law Society has brought itself into compliance with the, I almost said the acronym, Accessibility for Ontarians with Disabilities Act 2005. Finally, networking with other law societies is part of the work of the Equity Department. That is described in your report, page 139 of Board Books and following. I want to congratulate this department for its hard work. I actually cannot believe how much they are able to accomplish. This is just a very fast flyover of the report, but I want to thank Jose Broussard very much on behalf of Jimmy Faulkner and myself, and thank you for your attention. If you have any questions, one of the three of us may be able to answer.
Thank you. And thank you again to the whole department, very committed and hardworking people with who produce results. Okay, any questions or comments? Oh, listen, don't go too far. Okay, Mr. Wright.
Ms. Lieber did not want to read the comments, but I think for the record it should be pointed out that the comments were extraordinarily complimentary of their work.
Thank you, Mr. Wright. Any other comments or questions in the
The
room?
conference is no longer in lecture mode.
Any questions or comments on the phone?
Suzanne Clement, yes. I just wanted to congratulate you guys. I read the report and I was very, very impressed with its content and work. I just wanted to add, in terms of the access by women, one of the areas that I found in my work that beyond the work-life balance issue is very much a question, particularly in large firms, is the values and the culture in the firms, was in all of the women that I've had an opportunity to speak with, was the key issue. So it's one I think that the committee could be looking at in the future, but I just wanted to congratulate you on the quality of the report.
Thank you very much. In fact, a considerable amount of work has been done in a collaborative way with law firms through the Justicia project, which was adverted to sort of briefly earlier. But obviously that's work that needs to continue. Thank you. Mr.
I feel considerably.
Mr. McDowell, sorry.
I just wanted to ask one of the members of the committee that, as they may know, there was a major decision delivered by Justice Rouleau on the provision of French language services in the criminal sphere, Monconda, which kind of is a survey of the applicable law in the criminal context. And I wonder whether we've considered the extent to which that paradigm should apply in our world, and how close to compliance with that we would be.
Well, I feel like the question was almost a setup for us, because on the last meeting of the Equity Committee in early May, we actually, at the meeting, I circulated the judgment. It turns out it was argued by a bencher colleague, Richet's husband, Jean Richet. So naturally, surprise, who brought it to my attention? But the judgment is of huge significance, and we circulated it, and we were lucky enough to have Miss Julie Lasson present on behalf of AGFO in respect of the delivery of French language services. And that issue occupied some half an hour to 45 minutes of our time at our last committee meeting. And I can tell you that it remains obviously front and center in terms of making sure we're on side, not just with the letter of the law, but the spirit of the law.
Thank you, Mr. Faulkner. Any other questions or comments in the room? Questions or comments on the phone? I think we already asked, but I'll ask again. Okay, thank you very much.
The conference is in lecture mode.
I think we'll move to our morning break now. Okay, next, Tribunal Committee report, Mr. Anand.
Thank you, Treasurer. The Tribunal Committee report has two matters for decision. The first in public, which I'll deal with now, and that's at tab 6.1, page 173 of board books. And that the Tribunal Committee asks Convocation to approve the practice direction respecting a Tribunal Book of Authorities as set out both in English and French at tab 6.1.1, 6.1.2. Just for your information and to remind Convocation, the Tribunal Committee, its task is essentially to create policy options in conjunction with the Tribunal Chair who attends for approval by Convocation, and to formulate rules, again, in conjunction with the Tribunal Chair for approval by Convocation. And this practice direction is the second practice direction that Convocation has been asked to approve. Those of you who have been involved and those of you who have had the tribunal orientation will know that there is an adjournment practice direction, and these are intended to provide notice to the profession, to the users, to the tribunal members of policy and practice in order to create greater consistency in the interests of the tribunal and in the interests of the parties. And the practice direction on Tribunal Book of Authorities falls within that category as well. And so, as is done in some courts and other tribunals, the proposal is to create a Tribunal Book of Authorities consisting of leading cases, which are frequently referred to, and those of you who have sat on the tribunal will know this, that if you kept a copy of every one of the, each time a certain case was provided to you, you would have a room full of them after a while, and this is designed to cut down on that, and also to provide some assistance to self-represented respondents and others as a sort of first step, I guess, in terms of the research that they need to do in order to appear at the tribunal. So it simply indicates that parties are not intended to produce copies of these cases, and I'll come back to what these cases are in a moment, and that they can, and that's of course the Law Society as well as the licensee or applicant, can rely on any case included in the Tribunal Book of Authorities and need not reproduce it, and of course the Tribunal panel members will have access to this as well. The Tribunal Book of Authorities will be amended from time to time. It's not part of the practice direction that you're being asked to approve, because it will clearly be a moving target as the jurisprudence evolves. But you have a sample of what is intended beginning at page 176 of board books, in which the chair has taken a first stab at the Tribunal Book of Authorities that will be contained. It's set out first chronologically. There are some 37, then it's alphabetical, and then there's an index by issue. It's the same 37 cases indexed in different ways for the assistance of our users and for the assistance of tribunal members. The chair had the input of his roundtable, that is the chair of the tribunal, Mr. Wright, who's here, of course, had the input of his roundtable of frequent users. And a couple of weeks ago, there was a full discussion of this at the tribunal committee with the assistance of some 9 benchers elect at that time, in addition to the incumbent benchers at that point. This is not obviously a major policy step, but it's certainly a matter of evolution and convenience to the parties and to the tribunal as a whole. I should say that the motion asks that Convocation approve the practice direction respecting the Tribunal Book of Authorities to be effective August 17th, 2015. And because there's a delay of 2 weeks, I guess, like any renovation, I guess, in the opening of the new premises for the tribunal, the friendly amendment that is being put before you is that September 4th, 2015 be substituted for August 17th, 2015. So I'm moving this motion, seconded by my Vice Chairman Sleeper.
Questions or comments in the room? Mr. Gottlieb.
Treasurer, through you to Mr. Anand, this is a very good idea. Just want to clarify, the Tribunal Book of Authorities will be available in the resource section, and that will be publicly accessible. You won't need a password.
It'll be available on the tribunal website, I believe. So, which is of course publicly accessible.
The conference is no longer in lecture mode.
Mr. Sharda?
Yes, through you, Madam Treasurer. I'm wondering, when this goes up on the website, and if I'm a practitioner and I hit on a case, can we have it so that links to CanLII, or would I have to copy it and then search and print elsewhere, just from a practical, functional perspective?
Mr. Wright may be able to address that. It would link directly to CanLII.
Any other questions or comments in the room? On the phone? Questions or comments on the phone? None? Are we, where are we? Okay.
Seems to be.
Okay,
All
quiet.
systems go.
All quiet, okay, thank you. In that case,
Sorry, Janet, it's for Jenny, I'm sorry, I pushed the wrong button.
Okay, did you have a question or comment then?
Yeah, I did have a question. My question is this: when will the tribunal members then have electronic? Will be provided with electronic data totally as opposed to paper?
That's a very different question.
Well, no, but you've got the link, and of course, then we could sit in the, you know, in the hearing room with our tablets and access this. And would that be the only access? Is my question. Once we have this on there.
Yeah, no, I didn't mean to. I didn't mean to criticize the very different question, but it is that's an evolution that's taking place. Mr. Wright, maybe you want to speak to this for just a moment. There was a good deal of discussion about this at the Tribunal Committee, but this is a baby step in that direction.
Okay, and Mr. Wright.
So this particular book of authorities will be available to you both electronically and in hard copy. In terms of data access in the new tribunal premises, you'll have full access wirelessly to all of the functions as they are now. The tribunal is working on an electronic case management system. It is an evolution, though. It will take some time in order for other documents to be available to you fully electronically. The first step will likely be making those available to you to adjudicators outside of the hearing room, and probably electronic hearings are a few years away. And the Tribunal Committee and the Tribunal Office continues to work on the steps needed to accomplish that.
Thank you, Mr. Wright. Thank you. Any questions or comments on the phone for Mr. Anand on the motion? Okay, if not, call the vote. All in favor? Any opposed on the phone? Okay, carried. We're going to deal with all
the conference is in lecture mode.
We're going to deal with all the in-camera matters together at the end. And before we move on, I'd like to advise Convocation that there is a change of date for the Access Awareness event that I mentioned and is also in the material. It was scheduled for June 2nd, but it is now June the 4th. That's June the 4th. Okay. Paralegal Standing Committee report, Ms. Haig.
Thank you, Treasurer. Standing Committee, the Paralegal Standing Committee's information can be found at tab 7 on board books. We have 2 items of decision. One is in camera, so I'll deal with that later. The second matter we have before you today is a motion. You can find it tab 7.2, page 193 of board books. The motion is that the selection committee for the William J. Simpson Paralegal Award be expanded to include 2 additional members. We would like to see 1 justice or retired justice of the Ontario Court of Justice and 1 justice of the peace or member of a judicial tribunal. As you may recall, in September 2011, Convocation approved the creation of the Law Society Distinguished Paralegal Award. And on May 22nd, 2014, it was renamed the William J. Simpson Distinguished Paralegal Award in honor of Mr. Simpson's outstanding role in the creation of the paralegal regulatory model. The nominations for the award are currently reviewed by a selection committee comprising of 5 paralegal benchers of the Paralegal Standing Committee, the vice chair of the committee, a lay bencher member of the committee, and the treasurer of the Law Society or her designate. Other Law Society awards are considered by a selection committee with several outside representatives, including the Chief Justice of Ontario and a representative of the Ontario Law Deans. The committee was of the view that the selection committee's deliberations on the most appropriate award recipient would be enhanced by the addition of a judge and a justice of the peace or judicial tribunal member. Within these parameters, the choice of the 2 additional members will be at the treasurer's discretion. The motion is moved by myself and seconded by Ms. McGrath.
Any questions or comments for Ms. Haig? Questions or comments on the phone?
The conference is no longer in lecture mode.
No questions or comments, I'll call the vote. All in favor? Any opposed on the phone? Okay, carried.
The conference is in lecture mode.
And Ms. Haig, I wonder if I might ask you just to address 2 of the items that were up for information from your committee. The
Yes.
update on competence initiatives.
Absolutely, Treasurer.
And the referral service, thank you.
I'd like to briefly review the information at items The information items at tab 7.3, that's page 195 of board books. At our May committee meeting, the Executive Director of Professional Development and Competence, Diana Miles, provided the committee with an update on current initiatives with regard to paralegal competence. The first initiative was in respect to the revision of the paralegal licensing examination to increase the substantive knowledge component. This new examination will be administered for the first time this August. Some of you will recall that this change was approved by Convocation in October of 2012. This was a major project requiring the redefinition of required competencies and took 3 years to implement. Colleges have been required to review and if necessary, make changes to their learning outcomes to ensure that these new competencies are embedded within their course structures. And we look very forward to seeing the results of this examination in August. Secondly, the new accreditation and audit process for paralegal colleges was approved by Convocation in February 2014. This too will come into effect this fall. This includes the introduction of more stringent standards and criteria for program accreditation, the introduction of a mandatory re-accreditation process requiring colleges to renew their accreditation every 5 years, and implementation of a fee structure. Now that extensive work on these two initiatives is complete and are being implemented, the committee continues to regard enhancement of competence as a key priority and continues to consider possible further enhancements to the licensing process with this objective in mind. Once the committee had originally decided that these were the initiatives we wanted to pursue, Diana Miles and her staff provided exceptional guidance and extensive work to make it happen. The committee would like to express their gratitude for all the work that they have done over the last several years to implement these important and necessary initiatives.
Any questions or comments on that, for Ms. Haig on that report?
Thank you, Treasurer.
The
Any
conference
comments
is
or
no
questions
longer
on-
in lecture mode.
Any questions or comments on the phone?
Thank you, Treasurer.
Thank you.
The conference is in lecture mode.
I think we'll move to the Audit and Finance Committee report, Mr. Brett.
So, the report is at board books at page 223. Or at least the part of the report that I will take you through. So what you have before us here is just a summary of where we're at after the first 3 months of the fiscal year. And what I can say is the news is good in that you can see we're doing significantly better than our budget. And I'll just take you quickly through some of the key items so you can understand what's happened. In terms of our revenues, we're slightly below budget there, but we've more than made it up in a number of other areas. PD&C, which is essentially our continuing education, the revenues are much higher than we had budgeted. We're up a bit with our investment income. Under other, you'll see there's a significant over budget in terms of revenue there. What that relates to primarily is we've implemented late fees for people that don't pay on time. And what the Audit and Finance Committee had decided a year ago was that this was imposing significant costs on the Law Society, as we had to follow up with people who hadn't paid and so forth. And so to some extent this is a cost recovery, and you can see that we're getting some income in through that. When you look through the expenses, you can see that with the exception of the compensation fund, essentially we're doing better than budget on all of these areas. And what I can say is some of these are timing, but some of these will stick in the long run. The compensation fund we've talked about previously as a result of two major issues that have arisen. We've had to up the amounts that are going into the fund in order to cover that, and therefore we are above the expense. But the overall news you can see when you come to the bottom line is that at this point in time we had budgeted a deficit of about $900,000
and we're currently running a surplus of about 2.6 million, which is good news. So Treasurer, subject to any questions, that's a quick update on the first 3-month financial statements.
Questions or comments for Mr. Brett from the room?
The conference is no longer in lecture mode.
Mr. Udell?
Perhaps for those of us who are new and are not aware of the issues with respect to the compensation fund, this may not be the appropriate time, Madam Treasurer, but perhaps Mr. Brett could enlighten us a little to give us some background, because I know we do get things out in the hinterland as to what's going on with the compensation fund and potential claims, but I think it would be enlightening.
So just quickly, the 2 major claims we have relate to condominium projects where monies were being held in trust, and those funds disappeared from the trust accounts. There's still issues surrounding whether this is...
Mr. Brett, I'm just reminding you we're in public. A moment.
Okay, so I think probably that I think what I've said is publicly available in terms of that those are the issues that would relate to why the compensation fund. The other point, just in terms of the compensation fund, like all of our funds, there are policies that we have in place to govern the size that we keep of the fund. And with respect to the compensation fund, in the compensation fund, we have, in consultation with the actuaries, we need enough in there to cover 4 once-in-a-100-year events, so that there's more than enough to cover this. But this would then take us down within the towards the bottom of those limits, and these 2 events would both fall within the category of what an actuary would call a 1-in-a-100-year event. So. The policy was prudent, but we're going to have to start looking at increasing the fund.
In any event, Mr. Udell, we have a compensation fund committee, and no doubt they will be considering these policy issues or other policy issues related to that in the future.
Thank you, Madam.
Any other questions or comments? Oh, Ms. Besbury, I'm sorry, I saw you before.
I'm not sure if this is really a question or more of I hope this is a typo. At paragraph 12 of page 215, I've got it up here if you'd like to just,
I'm going to go right here.
Okay.
Okay, so I have it out here.
It says that the investment in 2 subsidiaries, Law Pro and Library Co. is certain amounts, and one of those is in millions and the other is in hundreds, and I'm suspecting that there should be more zeros after that. 100 amount.
I'm not sure. I see what you're. What's being raised is at paragraph 12 on page 215 of board books, and the shareholding in Library Co. is a nominal one. Is that a correct figure? Just
Yes, it is.
yeah. Yeah. So I think that is correct. There's not a lot of capital in Library. Okay.
Any other questions or comments for Mr. Brett?
The conference is in lecture mode.
Questions or comments on the phone?
The conference is no longer in lecture mode.
Questions or comments? Not? Thank you, Mr. Brett.
The conference is in lecture mode.
The next is professional regulation, Mr. Mercer.
Good morning. What you have before you at tab 10 is the quarterly report of the Professional Regulation Division, and I suppose it's noteworthy in a very small way that this is not the report of the Professional Regulation Committee, but rather the division, and that's a distinction worth noting because the committee has responsibility for rules, has responsibility for policy, has responsibility for oversight and aggregate reporting, but Convocation should be aware that we don't have responsibility as a committee for individual cases, given the division of responsibility and given that benchers are adjudicators as well as policy setters. So I just want to say at the outset that this is a report from the division, not from the committee. I'll take you briefly through the report starting at page 243 of Board Books. What you have at page 243 is what's called the performance in the Professional Regulation Division. And what this report is essentially provides an understanding of the processing in an aggregate sense of complaints. And so you'll see on page 243, page 5 of the report, that we typically receive about 1,200 complaints in any quarter. So obviously if you multiply by 4, we get nearly 5,000 complaints a year that have to be processed through the Professional Regulation Division. You'll see the components of that. There are some lawyer complaints, there are some paralegal complaints, there are some other types of cases that aren't truly complaints, but we call them that for the purpose of stats. What I think is worth understanding from this is two things. One, you'll see that the trend line is slightly downward, and that's probably a good thing, but not certainly a good thing. It illustrates that we have a regulatory approach which is predominantly complaint-driven. We receive as a law society complaints. The law society sees in the press or otherwise things which it considers should be processed as complaints, I suppose. But we don't actually know whether or not when complaints go down, that's because fewer people think the law society is useful to them in a complaint, or whether it's that fewer complaint-worthy things are happening in the professions. And so I simply highlight that the nature of our process is reactive in the sense that we mostly receive information. It's mostly retrospective in that we're dealing with past conduct. And in significant part, it's punitive, although the number of cases which ultimately result in hearings and sanctions is low. And it's important to understand our regulatory process in that sense. There are four major components of the Professional Regulation Division. The first is intake, and that is reported starting at page 247 of Board Books. And intake, oddly enough, is the place where stuff arrives. It is a sorting process, essentially, and it sorts out into 3 categories, broadly speaking. One, the category is we shouldn't be doing this, we don't have authority to do this, it's not within our jurisdiction. The second goes to complaints resolution. The third goes to investigations. And the point that I want to make there is that some things that PRD learns about are obviously on their face requiring of an investigation and a possible sanction depending on how the case investigates out. Others are practical day-to-day problems that require practical resolutions. And of course you can't sort those perfectly, but the complaints resolution side is intended to deal with the former, and the investigation side is intended to deal with the latter. Complaints resolution, you'll see the input, the output, and the inventory starting at page 250. And of the 1,200 or so each quarter that we receive in the system as a whole, you'll see that about 400 of those, plus or minus, go into complaints resolution. So about a third, referring to them as minor is probably the wrong way to describe it, but those which are thought to be capable of resolution, not necessarily, but problems capable of being resolved or hope to be resolved. You'll see at page 252 of Board Books the departmental inventory, and that's a useful way of understanding whether we're falling behind, whether we're in steady state, or whether we're catching up. We know other regulators around the world have got in trouble, legal services regulators, when they can't handle the volume of complaints which are coming at them. And so one of the things that we pay attention to, both in our self-interest in maintaining self-regulation, but also in terms of being an effective and appropriate regulator, is whether or not the inventory is going up or the inventory is going down. You'll see at page 252, again, that in complaints resolution, while life is lumpy, it's not always a perfect line. Generally, the trend is a good trend. We're keeping a pace. The investigations is the department or the group which receives the more serious matters from intake. And you'll see a report there at page 254. And as you'll see there are typically 300 and a bit cases coming into investigations each quarter. And so if you could multiply by 4, you'll see that there are 12 or 1,300 each year coming into investigations. Those are the ones which are likely to take greater time, likely to be more complicated, often relate to more than one issue, whether it's a separate complaint or multiple issues within one complaint. The page 255, I think, is a helpful way of understanding the work of the investigations group. You'll see at the bottom of the chart that the investigations group closes about 250, 240, if I'm estimating it out right, each quarter, and transfers out, hard to pick up an easy average, but something in the range of 50 or 60 each quarter. Transferred out means transferred out to discipline. So of the cases that we're receiving each year, say 4,800 to 5,000 in total, it looks like something in the order of 150 are transferred out to discipline, and that gives you a sense of the hearing volume as well, because that which goes to discipline, for the most part, not entirely, goes out to hearings. At page 256, you'll see the investigations department inventory, and it's stable. There was, you could have argued in the early parts of 2014 that we were in a positive trend. If you're looking at the latter part of 2014 and early 2015, it looks like we're in a slightly negative trend. But I said life is lumpy, and the idea of deciding that you can learn anything from 2 or 3 quarters is wrong. What we have is a generally stable inventory of cases and investigations. There's a distinction to be made in investigations that Convocation will want to keep in mind going forward, and that is between what are cheerfully described as the core cases and the mortgage fraud cases. And core really means everything but mortgage fraud. And you'll see on page 20, page 257 of board books, the aging of investigations. That's obviously important, not just in terms of ensuring that we're getting our work done in an orderly and efficient way, but it's important both for the complainants and for those who are responding to investigations that we work through investigations in a reasonable way, a reasonably efficient way. What this tells you for the non-mortgage fraud cases is that something in the range of 2/3 are dealt with in less than 10 months. Something in the range of 1 in 5 is dealt with within 10 to 18 months. My eyes don't work as they once did. And then there are a group which are probably 1 in 5, a little bit less than 1 in 5, which take longer than 18 months. That is not uncommon. Obviously it's 1 in 5, it can't be uncommon, but it often relates to new complaints coming in, multiple complaints, the difficulty of investigating when other parties are the sources of information and they're not necessarily as prompt. But it also can be an indication that we're not proceeding as well as we should. And so while one can explain away much of the over 18 months, it's something worth paying attention to as benchers over time. The mortgage fraud cases are at the next page, and you'll see that there are more of those in the over 18 month, probably a quarter, approaching 1/3 rather than something less than 1 in 5. And we know that that is the case because mortgage fraud, by its definition, by the nature of the fact patterns, ordinarily deals with multiple transactions, the selection of which transactions go forward. Multiple transactions are harder to investigate and take longer time. We also have, within mortgage fraud, a tendency, not true in every case, to have multiple parties involved, and so that can complicate as well. I'll spend almost no time at page 260, but so you have it, where complainants are unhappy with our conclusion that we should not refer the matter to discipline. Complainants have the ability to go to the Complaints Resolution Commissioner, who acts, as I suppose, as a safety valve or an ombudsperson to our process. And you'll see that those are reported at 260, and it's something in the range of 50 or 60 a quarter, so a couple 150 a year, which out of 5,000 in total would appear to be a good ratio, but again, one always has to be concerned that people don't see a process as not useful enough or unknown to them and therefore not used. I'll skip over cases in discipline because the output of investigations is discipline and the output of discipline is hearings, and go straight to hearings, noting only that the discipline inventory at page 262 is on a downward decline over time, and that appears reasonably consistent, so that's a comfort. What you have at pages 263 and following are the cases in discipline in the hearing system. Completed matters are set out at page 264, and you'll see that the hearings amount to 30 or 40 a quarter, so 120 plus a year. That's the public face of the 5,000. What the public doesn't see and what most of us don't see is the 4,800 or so that are dealt with otherwise. And finally, you have at 265 the appeals from the hearing division. First of all, the appeal division, and we typically have 20 or 25 appeals within the appeal division each year. And then you'll see the divisional court, judicial reviews and appeals, and court of appeal, and the volume. So you can view a lot of this as like ducks, where most of the activity is under the water. What people see are the hearings and that which is in the court system, and that's the upper part of the duck. At 267 and 268, you'll see at 267 a chart providing what I hope is roughly what I just told you in terms of the processing of regulatory matters that come into PRD. And finally, at 268, you'll see the people part of it, with Zainab Onan, our Director of Professional Regulation, who leads this group. And then you'll see the boxes and the people leading the boxes for intake, complaints resolution, investigations, discipline, which is what I've talked about. Monitoring and enforcement, which is what follows after orders are made. Where orders are made that require follow-up enforcement monitoring, that's the group that deals with that. We have a disclosure unit and a risk strategy unit managing oddly enough, disclosure, but also trying to work towards a more nuanced and sophisticated understanding of which cases require regulatory attention through risk strategy. Compensation fund and trustee services. You just heard about compensation fund. There are also trustees appointed to practices. Case management is a unit designed to try to make sure that cases in our system move forward promptly and efficiently. And then you have our senior counsel in the Office of the Director, Senior Policy Counsel, who provide senior leadership within the division. And so I've used the quarterly report as an excuse to describe something for you, and I hope that was of assistance.
Thank you very much, Mr. Mercer. Any questions or comments in the room for Mr. Mercer? Mr. Bannock?
Thank you, Treasurer. Mr. Mercer, I'm concerned about the length of time lawyers may be subject to the entire process, from complaints to conclusion. Page 16 is terrific in giving us an aging of the complaints process. Page 20 is terrific, or 257, for the aging of the investigation process. I don't see a comparable aging for the discipline process. But regardless of that, I'd invite you to consider with the committee the possibility of informing Convocation of what the aggregate is. For the cases that start somewhere and in fact have to go through the whole process and maybe each milestone time because many fall off, how long are our lawyers subject to a process to expect is a reasonable standard for us as a law society to accept as being appropriate for investigation and engagement?
Yes. The first part of this is the overall input and output for the division as a whole, and perhaps that's a logical place to put that overall point that you make, which is a strong point.
Well, pardon me, Trevor, can Convocation be provided with the aggregate the result of all 3 phases.
I think the answer to that is yes, but I don't know that to be so, so let's go off and see what can be done. It's a sensible request, of course.
Thank you. Any other questions or comments in the room? On the phone?
The conference is no longer in lecture mode.
Questions or comments on the phone? Thank you, Mr. Mercer. I think we're have completed
The
the
conference is in lecture mode.
in public part of our proceedings. Before we finish, however, I did want to draw your attention to the fact that Doors Open was held this weekend. It's a province-wide program where public has the opportunity to enter and tour buildings that are otherwise not open to the public. Osgood, including but most of our bencher quarters were on the tour. I was Exhibit A in here on Sunday afternoon, and I want to pay tribute to Elise Brunet and her staff. Elise Brunet, for the new people, is our curator. She did an amazing job of organizing all the volunteers and the tours. There were 6,000 people on Saturday and 6,000 people on Sunday, for a total of 12,000. And it was really an excellent event. People who came in here where I was were just thrilled to be inside this building, and it was great to be able to share it with them. So thank you, Elise. Okay, we'll move into in camera now, please.